Okay, today we're going to talk about the Texas court system. That's going to take us through a description of the courts in Texas and their jurisdictions, how they work, some of their overall problems. We'll also talk about the criminal justice system in general in Texas, the law enforcement system, the court system, which we'll cover right in depth in this chapter, and a little bit about the correctional system as well. But to start off and have an understanding of what the court system deals with, we're going to first look at where law comes from. And generally speaking, law comes from 4 different places. It has 4 different origins. These build one upon another. And so we'll start at the base level of the original level, the lowest level of origin for law, and that is what we call common law. And common law is the law that most of us generally think of when we're thinking about what the law is and how it developed and who it applies to and how it works. But essentially, common law is the historical development of law over time. And for us in the US to understand the mechanics of it, we have to go back into British history and see how it started there and then how it developed over to us. Now, the US as a country is rather interesting because we have multiple histories of law, right? I mean, generally speaking, the US and most of the states have their law coming out of this history with Great Britain, but if you look at a state like, say, Louisiana, you're going to see a history of law coming out of the French perspective. And then when you look at Texas, you're going to see not only the British history, but also a Mexican history of law and a Spanish history of law, all kind of melding together to give us some perspective on this. And this was apparent. We talked about this as some of the overlap of these different histories when we talked about Texas constitutions and some of the important parts of the Texas Constitution and how it came out of our history. So this first origin, this common law origin, is one that for Texas, we're going to look back to the English common law system. And what we have there, if you go back far enough, is law is something that's an edict from the monarch, right? The monarch says this is the law. The sheriffs, which have a long and distinguished history in English common law, sheriffs were responsible for applying that law, right? And then they would arrest people and hold them for trial. As the English system was developing ideas of individual rights and the ability to defend yourself within a legal system. And so a person would be arrested by a sheriff and held over for trial. The person responsible for that trial was what were called at the time circuit judges. And what circuit judges were folks that were appointed by the crown who ostensibly had training and experience in the law of the land. And they were assigned a jurisdiction that they were to be the judge over, and they would travel from town to town and deal with those that had been arrested for breaking the law in those provinces or territories or areas. What they started doing that gave us this idea of a common law was they began, of course, keeping track of their decisions. And so, judge comes into town, folks that are arrested are brought up and arraigned before the judge, and they have their trial. Evidence is brought forward, right? Witnesses are telling their story, the accused is telling their story, and the judge has to make a decision as to what really happened, what were the facts, try to establish those, and say this is from what we can tell true. This is not true, and here's how this comes together, and then make a decision on guilt or innocence, and then if a guilty decision, make a decision on punishment. And these judges, right, that were riding these circuits between these areas started recording their decisions. They started recording their facts, recording their decisions during the trial, and then recording their overall guilt or innocence decisions, as well as then the accompanying punishment if there was a guilty decision. And so you had this accumulation of decisions from circuit judges as they went around doing their job. And they shared these with one another, essentially the beginnings of law libraries, I guess. And they discussed their decisions and what they thought was fair. And the other thing that was happening here is that they were carrying these decisions with them from one city to the next. And so what they had was a record of what they had done. And when a similar case would come before them, they had something to look back at for continuity, right? And they would say, okay, well, this person's accused of stealing something of a particular value. Here's the facts for or against them. I had something very similar in the previous town. The decision I made was this. The punishment I meted out was X. This is fairly similar, so I will use my past decisions as a guiding tenet of how to apply the law consistently and punishment consistently in this trial that seems to be very, very similar. All right. So what you have are these judges going around building historical precedent, right? In other words, a decision in the past that they're going to use as a guideline for making similar decisions in the future. And that's still the idea of precedent, a guiding tenet to how we do law in the US and in Texas today, right? We look to historical decisions, we look to historical sets of facts, we look to the legal justifications that were used for the application of law to a particular set of circumstances. And we try to find cases that are similar and decisions that are similar in the application of the same law, so that we can be consistent over time and that we have a historical development that makes sense. And so we still do that today, right? All courts in Texas of a certain level, right, of importance, develop a record of the facts and the parties and the law that's entailed and the application of judicial decisions from the benches, and then the application of either guilt or innocence from either the judge or jury, and then the application, if guilty, of appropriate punishments. So that all of this is continuous and has a general application of fairness over time. This process of recording these decisions and using this history as a precedent for making future decisions is developed out of this idea of the common law, right, where the judges made the law as they went around and made their decisions. And this history goes back hundreds of years, and we still use it today. If any of you go to law school, your first real exposure of how to figure out what the law is and how to apply it will be getting sent off with hypothetical cases to the law library to research the history of this problem over time and how law has dealt with it and where we sit today and how we should use that as a stepping off point for whatever's unique and different, or as simply a historical guide if there's nothing unique and different in the new cases. So precedent is still a very prevalent practice in law today. So the history of common law develops this out for us. So recognizing that history and using it is still very important. In any set of concerns about law and application and how it's going to be applied, you have to also remember what the basic fundamental law is, and that is the Constitution, right? The United States and Texas, 50 individual states, have constitutions that provide the fundamental law for that state and for that country. And it develops in that, as we talked in the chapter on constitutions, that constitution, right, is responsible for developing the governmental institutions, for determining how those institutions are going to work, and for providing scope to what those institutions can and can't do. And court systems are one of those three major systems that come out of the constitutions of how the government will work. And so the Constitution provides the fundamental basis of law that courts are based upon. Also, the operating parties that are developed from that Constitution, not just the courts, but the legislatures and the executive branch as well, are going to be making law as part of their common practice of what they as an institution do. Remember, we talked about how the legislature makes law. That's one of its primary things, is to take problems from constituents, propose bills to be new law, debate those bills, maybe pass them and make them into law. When they do that, they're following their constitutional prerogative to make what we call statutory law. So the law that comes out of the Texas legislature is referred to as statutory law. In other words, there are statutes, and they are making statutes. The law is putting statutes into place, and the authority for those statutes and the legislature to make that law rests in the Constitution. So our major lawmaking body, right, gets its authority to make law from the Constitution of the state of Texas. Not too differently, the executive branch has the ability to make what is called administrative law in its promulgation of rules as it implements new statutory laws. So the legislature passes a law. When it passes that law, it tells the executive branch, you're going to do this, right? You're going to implement this. And then that's implementation process is handed off to a bureaucracy, a state agency, whose job is to say, okay, here's the law that we've been given, and we have to make it work. Part of that making it work is to come up with implementation rules. And we'll, right, talked about that when we talked about the bureaucracy. So the bureaucracy, as it makes rules, is making what we refer to as administrative law. So it carries the effect of law, these rules do. They're based upon the statutory law, which is based upon the Constitution. So they're saying, look, we've been given the authority to make these rules, to implement this law, to get something done. And they follow a prescribed process of public hearings and debates and rulemaking, and where they listen to that debate and maybe implement some concerns of the folks that are going to be regulated by that law. But when they're done and they publish that administrative law, they publish that rule, it's going to have the effect of law. There are going to be the possibilities for punishment. Usually it's going to be financial, or it's going to be regulatory in nature, not necessarily on the criminal side of things, but it's possible. And the state is going to, right, apply that rulemaking, that administrative law, and it's going to affect people's business. It's going to affect people's ability to do things in society. So that administrative law has the same foundation as statutory law. It's tied to the statutes, which are tied to the Constitution. So constitutional law provides us, right, with the basis to make statutory law out of the legislatures. It also, to some extent, you can carry this on down to ordinances that come out of municipal governments and decisions that come out of county courts, or county courts, yeah. And then the administrative law, right, which comes from the rules issued from an executive agency. So those are your four origins. Common law, which gives us this historical precedence. Constitutions, which lays out all of the rules of how things are going to work and who the players are and what their powers are. The legislature is one of those groups, and they have the authority from the Texas Constitution to make statutes, which create statutory law. In doing that, they create administrative parts of government, right? The bureaucracy, and the bureaucracy through that statutory law has the authority to make rules, which are considered administrative law. And so these all follow one upon another. The historical precedent idea that comes about through common law is used both in constitutional law and statutory law and administrative law as well, right? As constitutions are written, they look to history. As new statutes are written, they look to previous statutory precedent. As administrative law rules are written, they too look to precedent in the past and look to, hey, here's a law that was passed that's very similar to this. It has generally the same effect, but it's on a different group of people. We might need to implement this the same way and have the same administrative rules in place. So these are your four origins of law. When you look to the state of Texas, they go all the way back to English common law, come up through the development of constitutions, both at the national level, the state level, and that generates the statutory basis for law as well as administrative law. All right, so while we have those four origins of law, we also have two different perspectives of or types of law that exist out there. We have criminal law and or civil law. And it's always imperative that you know which you're dealing with, because the impacts of the application of one of these laws or the others carries different results. So we'll start with criminal law, which is what you see most often when you're watching criminal dramas on TV. They're dealing with criminal laws where an individual usually has been charged with breaking a law, and the breaking of that law, say an assault on somebody else, carries with it the possibility of punishment. And the idea here is that this government, whether it's a city government, county government, state government, or national for that matter, has a determined interest in protecting the safety of individuals, ensuring peace within the administrative areas of the state. And when that peace is broken, the individual that breaks the peace is subject to punishment from the state for breaking the peace. And so an individual that is charged with breaking the law may be criminally punished. And that criminal punishment is unique in that it may carry with it incarceration, or in some states, Texas being one of them, the extremity of punishment of the application of the death penalty. So criminal law, right, actually reaches out and punishes an individual for breaking the peace. It could be as minor as a fine. It could be as extreme as you sacrifice your life for breaking that peace. So criminal law is going to be the state punishing an individual and extracting some kind of payment out of that. That may include incarceration. The usual perspective of when someone is eligible to be punished by the state is when the certainty of guilt reaches a level that we refer to as beyond a reasonable doubt. And the idea here is that the state using its power to punish someone is a fairly intimidating and awesome power that needs to be backed up by some kind of surety, right? Some kind of expectation of appropriateness and applicability and exactness. In other words, we don't want the state punishing people without being very sure that they're punishing the appropriate individual. And the rule here, the perspective here of the state having to have established a level of guilt beyond a reasonable doubt means that most reasonable people looking at this situation would come to the same conclusion, that guilt was apparent and that punishment was necessary. This is one of the reasons in Texas we apply the opportunity to use trial by jury in most cases in a court, right? You can request this. And the idea being that we want to make sure that before we deprive any individual of their liberty or their freedom, that we have reached a standard, this beyond reasonable doubt standard, that says, we're really, really sure you're the culprit here, right? And you're the one deserving of this. And the idea is that we're going to err on the side of caution before we use the power of the state to punish an individual, especially if it involves incarceration. So for criminal law, we have this higher idea that someone must be perceived guilty beyond a reasonable doubt. And that if in the process there is still reasonable doubt in the judge and or the jury about the guilt of someone having done this act, then they should not be punished. So the base level is to argue that we're going to assume innocence of the person charged with a crime. And we're going to expect, there to be a healthy and hefty amount of evidence that persuades judge and or jury that the person is guilty before they apply a punishment, before they apply guilt and then a punishment. So this is what applies in criminal law, is this idea of beyond a reasonable doubt, which is hard to put a percentage on, but it's probably needs to be something pretty high if you were going to try to apply a percentage, right? You would need to have a perspective that you've really got the right person here, that you're 95 or something % sure that that's actually the culprit, right? You need to not have any doubts in your mind as a juror or as a judge when you apply a guilty label to this individual. And so that's a fairly high bar to reach, right? We don't want people being convicted and then being punished if we're not really sure they did it. And for criminality, that makes a lot of sense. Now, for civil law, we're not looking at a breach of peace against the state of Texas. Civil law is looking at usually some violation of an agreement between parties, between individuals. And I think the easiest way to approach this is to think of it as disputes among contracts and what a contract means and what an agreed upon expectation of behavior is between parties that are trying to do business together in some sense. So here, what we're talking about is individuals that have come together and have developed some kind of pact, some kind of service agreement, some kind of contract that says, I'll give you money, you'll provide this service. I'll provide this good, and you'll provide me with some kind of compensation for it, whether it be service or money or something else, right? And there's an understanding there of a civil agreement between parties. And so civil law is usually the application of the terms of the agreement, with a judge sitting in, or jury sitting in a perspective looking over this and trying to determine, did these people have a contract? Did they have a meeting of the minds? Was there some common expectation that needed to be delivered here? And so you generally have something like a contract dispute, and the arguments that are being made are, I offered this service and I did the service and was expecting payment of a certain amount and didn't get it, or I was paying this person to do something expecting service of a certain quality and didn't get it, or I purchased this thing and the thing never arrived, or when it did arrive, it was not in the condition that was supposed to be in. And then the civil system is sitting there to make judgments in these cases that are going to probably deliver something of a monetary damage, or a requirement of fulfilling obligations or request or service or something like that, or maybe both, right? But what you don't have in the civil system is any kind of charge of criminality, that there's been a peace broken of the state, that the person that is accused of doing wrong here needs to be punished by the state, right? The civil system is set up to make disputes between parties get solved so that parties are generally made whole again, or in no worse situation than they were before the contract or before the dispute. So the level, right, of threat here to the individual and their freedom or their perspective is a lot lower, right, in civil cases. Additionally, what that means is that the results of a civil trial are going to be less impactful on the individuals involved, right? It's going to be some determination of a fine or a damage that's paid out, and it's usually going to be monetary or maybe a service act. Therefore, with less on the line, we see a different standard applied to how we figure out if someone is right or wrong in these cases. And what we use is a standard called preponderance of the evidence, which really means that as a judge or jury, you're certain beyond a 50% perspective that one side has not lived up to their obligations and needs to provide some kind of compensation to the other side. Preponderance just meaning more than half, generally speaking. So, right, the level of certainty here is much lower because the damages that are possible are much lower. It's going to be monetary. It's going to be providing a service, right? There's not going to be loss of freedom or independence and jail time or something like that. And so we have a lower level of certainty that's necessary to come to an idea of guilt or innocence in this situation. And we really won't even talk in civil cases of someone being guilty. We'll talk more of them, owing someone or not having fulfilled terms of contracts. The idea of guilt is usually much more focused on the criminal side of things. So those are the two types of law that you're going to see when you look at the court systems in Texas, the different courts in Texas. Some of them will be courts of civil law. Some of them will be courts of criminal law. Some of them will be courts that deal with both criminal and civil law, which means those judges are going to be applying different standards and different laws and as they move through it. And so you always need to be aware of which type of law you're talking about, and what that means for the application of guilt or innocence, or right or wrong, and then the penalties that are possible. So courts, right, are going to be dealing with either civil law or criminal law or some mixture of both. Courts also have what we call as a jurisdiction, which is a boundary around what they can do and what their actual job is when they're looking at cases. There are three different types of two different types of jurisdictions, and then different applications of those two different types. Generally speaking, courts either have original jurisdiction, appellate jurisdiction, or some kind of mixture of the two. So let's talk about a court of original jurisdiction. anytime a court is making a finding of fact and rendering a verdict, in other words, they're saying, here are the things that we know that are true given what the evidence shows us, and here's the decision we've made about right or wrong, guilt or innocence, that's a court exercising original jurisdiction, right? That court is making a decision, an application of the law to a certain set of facts and a certain set of individuals. And most of the time, this is what we're thinking about when we're thinking about what courts do, right? We're thinking about courts exercising original jurisdiction, making some kind of decision that says, you are right, you are wrong, this victim deserves some compensation, the state needs some kind of compensation, right? So you're deciding as a judge or a jury in this court, guilt or innocence, right or wrong. And the decision then carries the weight of whatever the appropriate penalty is. And that's any court that does that is a court that's exercising original jurisdiction. Some courts, though, have the ability to oversee decisions of original jurisdiction that were made in courts lower than them. And that oversight is looking at whether courts and judges below that court made the proper application of law. Did they apply the right law? Did they apply it the right way? Did they make sure and use the right applications of guilt and innocence and punishment when they were, as a court, right, working their way through a decision? Did they admit the right evidence and exclude the right evidence? Did they allow the right witnesses and exclude the wrong witnesses? All of those decisions that a judge makes during a court of original jurisdiction are subject to review by an appellate court, right? That appellate court's job is to look back at a lower level court's practice and say, in this case, you did things right or you did things wrong. You applied the law appropriately or not. So an appellate court is a court that is offering oversight over decisions that were made in a court of original jurisdiction. And so those judges are trying to discern whether the lower court that was original, like applying original jurisdiction, did things properly. And if they did, then they say, hey, your decisions are sustained. The person that appealed this to us that said you did your job wrong, we're going to tell them, no, you didn't. You did the right thing. Or if, right, someone appeals and says, hey, this judge didn't apply the law correctly, as an appellate court, we're going to sort through all of those decisions you made. And it may be the case that we find that you did not apply rules of procedure or rules of evidence in the courtroom appropriately. And we're going to tell you to fix this, to rehear that and apply that law correctly and to do the job the way it's supposed to be done. So an appellate court's job is to review that lower court's decision, see if the decisions were made appropriately or not. If not, then to remand it back to that court with instructions on how to do it right. And then that lower court's job is to fix that problem and to do it again. So courts are courts of original jurisdiction. Some courts are exercising appellate jurisdiction. And in Texas, when we look at courts, we see some courts that are only original jurisdiction or only appellate jurisdiction, and refer to them having exclusive jurisdiction in that type of case. So a court that can only hear original jurisdiction cases, they're only going to ever find guilt or innocence, right or wrong, but never have any appellate responsibilities. Right, they're exclusively a court of original jurisdiction. Whereas, say, the Texas Court of Appeals, all they hear are appellate cases, right? Cases that have been appealed to them. And so their exclusive jurisdiction is going to be appellate. right? They're going to have exclusive appellate jurisdiction in Texas. And then you're going to have some courts that have concurrent jurisdiction. They will have areas that they exercise original jurisdiction, where they're finding fact and guilt and innocence or right or wrong. And they will have the ability to act as appellate courts for courts that are lower than them that are exercising original jurisdiction. So those are concurrent, right? They have both original and appellate jurisdiction. As we go through the different courts in Texas, one of the things that we will point out is whether they have original jurisdiction, what it is, whether they have appellate jurisdiction, what that is, and is it exclusive or is it concurrent. The slide that's in front of you now is the slide that shows the courts of Texas, what their jurisdictions are, what the limitations on those jurisdictions are, whether they're original or appellate, concurrent or exclusive, and how a case would be appealed from a court of original jurisdiction to an appellate court, or maybe from one appellate court to another higher level of appellate court. So those black lines, arrows that you see here are showing levels or directions of appeals and how they move appeal from one level of court to another level of court. So what we're going to do now is we're going to actually move through this whole diagram, looking at these individual courts and what their jurisdictions are. And the reason I spend the time doing this is because as we step through these courts and looking at their jurisdictions, what they can and can't hear, you're going to see some of the problems that have developed historically over time as we've created new courts and shoehorned them in here, and some of the confusion that is there as to what court has what jurisdiction over what kind of case, and some of the fallout that comes from that. So we're going to start at the bottom of this, and we're going to move our way up. The bottom level here are what we refer to as local trial courts of limited jurisdiction. These are courts that are either based in precincts of counties or are based in municipalities, cities. So we have two types of courts here. We have the justice courts and the municipal courts. Justice courts are courts that exist at precinct levels within county. Every county has 4 precincts. Every precinct has a justice court. Justice of the peace is what we usually call them. And as you can see, looking at this, right, they have a limited amount of things that those courts can hear. So let's look at the justice courts. In Texas, right, we have 821 of these justice courts that have their own judges. So you have, right, each court has a judge. Those justice courts, those justice of the peace courts, can hear some criminal cases and some civil cases. So let's look at that. They can hear civil cases or civil actions where the debate or the dispute does not exceed $10,000, not more than $10,000. So if you have a civil case where someone is asserting, hey, we had a contract and you didn't follow through with that, and I want the court to make me whole on what I paid you for what you didn't provide. And let's say, you know, it was something along the lines of I was paying to have an irrigation system put in with an irrigation company, and they quoted me $6,000 to put this system in, and they came out and they did what I would consider to be a very poor job in doing that. It wasn't worth $6,000, or it doesn't work. We had a contract for delivery of a working system, and I was going to pay them $6,000 for that. I could take this because it's a civil action, right? There's no one here going to jail. We're trying to get a decision made about what I'm owed and whether they come fix the system to a certain level or they give me money back. It's less than $10,000. I could file that case in a justice of the peace court, and that court would have the original jurisdiction to hear that case and limit and levy some kind of decision. Small claims is the same thing, right? We're looking at $100, $75, something, a couple $100 dispute, and the court can hear that and make a judgment on that. So those are civil actions, right? Where the judge is going to be making fairly small decisions. I mean, $10,000 is a lot of money, but in the big scheme of things, it's a small decision as far as legal decisions go. They also have the authority to render judgment on criminal misdemeanor cases. And in this case, those are defined as criminal misdemeanors that are punishable by fine only. So in other words, if a case is, right, the police arrest you from something and issue a summons to court, and that summons is going to result in you possibly paying a fine if you're found guilty of that, then it can be tried in a justice court. You're not going to jail if you lose this case, right? You're going to get a fine of some kind. And generally that fine is going to be similar to, like the civil cases, you're talking several hundred, $1,000, $2,000, right? And so we're looking at low-level misdemeanors here that carry only the possibility of a monetary fine. And these judges, right, that sit in these justice courts can make those decisions. The final jurisdictional area that we're looking at here for justice of the peace court are what we call magistrate functions. And magistrate functions are usually administrative decisions that are made by judges that have things to do with, like, issuing marriage certificates, marrying people, issuing a death certificate, right? Something that requires an official decision made by administrative law, a judge of some kind. And so they have these abilities to magistrate and make a decision and help move things along where people need some kind of official decision based from the government at a low level. So when you go to the polls, occasionally you'll be asked to vote for justices of the peace in the precinct that you live, right? You'll have people running for this position, and you'll make a decision, you'll vote for people, and whoever wins that election will serve as a justice of the peace in a justice court. Okay, municipal courts are basically the same thing, except those are courts that are created by municipalities, by cities, right? So a city is incorporated by the state with authority to have, right, their own law enforcement and their own services and their own courts. And when a city council passes an ordinance, and that ordinance may be criminal or civil in nature, they also have the ability, right, to create courts, municipal courts, and appoint or hire or elect judges to be in those positions to apply the ordinances in that city. So a municipal court judge, right, is basically applying the ordinances of the city. You can see here that generally speaking, we're looking at 900 some plus cities in the state of Texas that have incorporated and have enough authority to have municipal courts, and they have multiple judges that they hire or put in place to run those courts. And so you have 1,500 judges. These numbers might vary a little bit on the municipal court side. So what do these municipal courts do? Well, they can hear criminal misdemeanor cases within the city limits of that city that are punishable by fine only. Notice that criminal jurisdiction there is exactly the same as the criminal jurisdiction that exists over in the justice courts. So you have, right, two different courts here that might be able to both hear the same case, right? If you've been arrested and issued a summons by a municipal police agency, you're probably going to go to the municipal courts, right? And they're going to hear those criminal misdemeanor cases with you. Whereas if you're arrested and given a summons, a ticket or whatever by a county police officer, you're going to go through the county system, right? Which is the justice courts through the appropriate precinct of the county. But they have the same jurisdiction. So if it's a criminal misdemeanor with no jail time, fine only, it can be heard in either of these. Notice the next thing here is an exclusive original jurisdiction over municipal ordinance criminal cases. So what that means is that when a city council passes an ordinance, and that ordinance has, right, the effect of criminal law within the city, says if you do this, right, we can, and you're caught, we can punish you as a city with this authority. That ordinance, right, which came from the authority of the city council, can only be tried by a municipal court, a city court, right, that has the authority to apply those municipal ordinances. So when a city passes an ordinance, the application of law and punishment for that ordinance can only be applied by a municipal court. Doesn't exist in the county level, so it couldn't go to a justice court. And that's why this is called exclusive jurisdiction. And it's original because it's a finding of fact and a guilt or innocence kind of issue on this criminal case. They also have what is called limited civil jurisdiction in cases involving dangerous dogs. That's just one of those vagaries of where a certain problem got nestled into a certain court. So dangerous dog cases going to be handled at the municipal level if it's within a municipality. And then they too have the ability to exercise magistrate functions within the city limits, right? That they have the authority as a municipal judge. Okay, so those are the local trial courts of limited jurisdiction. When findings are made, decisions are made, right? You as an aggrieved party may think the judge didn't do their job right, didn't apply the law correctly, and you can appeal out of the justice courts or out of the municipal courts to a county level court, right? Remember, those justice courts were precinct level, or 4 precincts per county. But the county level courts are courts that exist at the level operating at the county as a whole, over the top of the precincts. And so you would appeal, right, from these limited trial courts, local trial courts of limited jurisdiction, to a county trial court of limited jurisdiction. And so if you're wanting to have a decision, right, reviewed and looked at how the law was applied and whether it was applied correctly, you would appeal up to a county level court. Texas has 254 counties. So we have 254 constitutional county courts. So it's important that you look at what the name here implies, right? Our Constitution in Texas says that every county will have a county court. So the Constitution, right, provides for 254 county courts. And so those are constitutionally derived courts, 254 of them. So we're going to look at those real quick. 5 levels or 5 different types of jurisdiction here in these constitutional county courts. And now think about this, right? You're looking at a county like Travis County. It has 1 constitutional county court whose job is to do the following things. It is given original jurisdiction in civil actions between $200 and $10,000. Notice that there's an overlap here, right? Those justice courts have civil actions of not more than $10,000. So it's possible that you could, right, take your civil action of $6,000 with your irrigator problem to a justice court or to the constitutional county court, which means that as a individual asserting some kind of damage, right, you're probably going to hire an attorney, and that attorney is going to try to figure out where to take this case, whether it's to the justice courts or the constitutional county courts. Both have jurisdictional claims, right? So you could go toward either of these. A little bit of confusion there. And if you're the person that's being accused of violating a civil action, this doesn't make you happy, because what you have is the attorney that's bringing the case for your whoever's aggrieved against you, making the decision about where you're going to have this case. And you don't have as much say in that as probably they do, because they're choosing where to file the lawsuit and to name you as a defendant in that lawsuit, that civil claim. Which means the judge on the aggrieved party side has some ability to look at potential judges and file cases in a court with a judge that might be more amenable to their situation than not. We refer to this as a practice called judge shopping or court shopping. And because we have these overlapping jurisdictions between different levels of courts, it becomes possible for the attorney of an aggrieved party to try to find a court that will be more favorable to them. This is, of course, a problem, because one of our assumptions is that judges are not going to be leaning toward either side of an aggrieved party, right, or an accused party when they're coming into the court. The judge's job is to, right, be fair and be impartial. But we've got this overlapping jurisdiction issue, which gives some authority to, or some ability to, an attorney to pick their judge, and maybe pick a judge that is a personal friend that they play golf with or something, right? And that's problematic, right? Now, hopefully, the judges, right, that are in place that have been elected are looking to be fair and impartial, and will, even though, you know, they acknowledge that that attorney is a friend of mine, right, we're acquaintances, we've worked together, whatever, I'm going to try to be impartial, and hopefully the judges will do that. But the potential there for problematic decisions is something you need to be aware of. Constitutional county courts have authority over jurisdiction in probate cases. Probate cases are where people have died and left their estate in a state where there's not clear legal instructions on how to dissolve that estate, and the courts are called in to make to handle contested matters between potential parties that expect to receive some of that estate. And so the judges are having to make a decision. If you look real quick to the far right side of this level here, you'll see there are statutory probate courts, a few of them in Texas. Statutory meaning that the legislature created these courts to handle probate issues. And the reason here is that probate issues are very complex legal issues, ones that can one, take a long time, require a lot of effort, and it's good to maybe have some judges who have a lot of experience in probate law. And so we have 18 statutory probate courts set up whose are limited primarily to just statutory or just probate matters. And so if a constitutional county court has the ability to transfer this over, or it falls under the authority of the statutory probate court, it'll go there. If it's going to be a highly contested case, the constitutional county court also has the authority to transfer this case up to a district court that has, judges that have higher levels of training and experience and might be able to deal with it. So probate is something that constitutional county courts don't want to deal with unless it's a fairly clear-cut situation. If there's a statutory probate court that can handle it, it will go there. If not, and it's very highly contested and intricate, they may transfer it up to a district court. So that's a little unique wrinkle in what constitutional county courts have to deal with. They have exclusive, original jurisdiction over misdemeanors with fines greater than $500 or that carry a jail sentence. So if the misdemeanor, criminal misdemeanors, is going to possibly result in you going to jail, you're going to go to a constitutional county court probably for that. They also can handle juvenile matters, so, where we have juveniles that have been accused of breaking the peace, this will be where they start with their case. And then the last jurisdictional element here that constitutional county courts have are called appeals de novo from the lower courts, or appeals on the record from municipal courts of record. So let me first address what appeals de novo mean. Latin for appealing from, of the new. And what this means is that in justice courts, those justices of the peace are making decisions, and when they're doing that, are only recording the decision they make, So they're not keeping an extensive record of all of the decisions they make in these very low-level cases where they apply the law. They're just saying at the end of it all, I decided X, here's the punishment that was meted out based on that decision. If you, as someone that received that sentence, thought the judge didn't do their job right, and you appealed it up to a constitutional county court, that constitutional county court is now being charged with looking at the decisions of this lower court justice and trying to decide if they did things correctly. However, there is no record of how the judge made those decisions except for the final decision of guilt or innocence. So without a record to review, they can't really exercise appellate judgment. So an appeals de novo, an appeal without a record coming new to the constitutional county court really means when you appeal out of the justice courts, the constitutional county court's going to have to rehear this case. That they're going to have to sit and make a judgment based upon the facts of the case as they find them new in the constitutional case, county case, because there is no record to really work the appeals from. Municipal courts, however, generally keep records, Municipal courts have come along at a later period in time. They're not constitutionally derived, They're keeping applications of here's what the ordinance said, here's how I applied it, here's the factors that came into play. So there usually is a record coming up with an appeal from a municipal court. And the constitutional county court can then look at that record and act in it as an appellate court and say the judge did make right decisions based on these ordinances or not. So where you have a record of the judge's decisions in a case, you will, as an appellate court, look to that record of decisions and make an appellate judgment on how they apply them. If there's not a record, then you're going to have to hear the case again. Okay, so the last one here to look at in this county level court one is the county courts at law. I noticed there are about 220 some odd of these. These numbers change and expand based upon need and upon what the legislature decides. The reason we have county courts at law is because constitutional county courts can't do their job, Remember, I referenced you have one of these constitutional county courts per county. So in a county like Travis or Williamson or Dallas, right, or Harris County, where you have millions of people living and there are thousands of cases coming forward, the constitutional county court does not have the bandwidth to handle all those issues, all those cases. So the legislature created, right, through statute, county courts at law. Their job is essentially the same as the constitutional county courts, right? Except they're created not by the Constitution, they're created by the legislature. And they're created by the legislature more recently, recognizing new issues and problems, recognizing the overload of the constitutional county courts, and they're created to handle that. So the first thing that you see as a jurisdiction for county courts at law is that they have all of the civil, criminal, original, and appellate actions prescribed by law for constitutional county courts. In other words, county courts at law have all the same things that constitutional county courts do as far as jurisdiction. That's what they're created for, to be an extension, to be more, right, than the constitutional county courts. Why do we do this? Why don't we just have more constitutional county courts? Well, to do that, you'd have to go to the Constitution and you'd have to amend the Constitution and you'd have to say, this county needs 6 courts. This county still only needs 1. This county, and so you'd need to have amendments to the Constitution addressing all those peculiarities, right, and caseloads in each particular county. Instead, you just leave the constitutional county courts alone, say there's 1 per county, you're the constitutional county. We, the legislature, will handle through statute every 2 years, putting county courts at laws out there to help with the load of cases. So all of the same criminal, civil, original, and appellate actions of a constitutional county court, but because the legislature can see these new issues, new problems, times change, values change, they add more to the jurisdiction of the county courts. So in addition to the previous one, they also give them jurisdiction over civil matters that go from $200, same as a constitutional county court, but now up to $100,000 and maybe even higher, depending upon the statutory law that gets applied to the court. And this is simply a recognition that, you know, things in the world are more expensive now, right? If you had a civil case dealing with, right, the developer of your house, right? 1876, when our last Constitution written, that'd be under $10,000 for the development of that house, as whoever was building your house. Today, right, that's much higher level. And so we're going to see the need for higher levels, especially in civil cases, right, dollar amounts. So the county courts at law can hear civil cases that have, right, a value that's in dispute of a much higher level than the constitutional county courts. And this is just recognizing that need for society's changed and values have changed, values as in dollar amounts. And the courts need to be able to address that. So you've got your constitutional county courts doing their jobs, and then you've got this legislature creating county courts at laws that help deal with those court cases, the vast, you know, majority of them. Notice the appellate line coming from county level courts goes to the Texas Court of Appeals. So if you think the constitutional county court or the county court at law or the statutory probate court didn't follow the law when they were deciding your case and you wanted to appeal this to have some review over how that happened, you would appeal it from these county level courts to the Court of Appeals. And we'll discuss Court of Appeals in a minute and what their jurisdictions are. Wedged in between there are district courts. District courts, districts, state districts are geographical areas that have been laid out by the legislature and courts created in those geographical areas. And they are state level trial courts. Right? The district courts are not looking at county issues, right? They're not looking at ordinances or things like that that are piling up, coming up out of municipal courts. Here we're looking at high level state law. So 445 courts, each of them have their own judge in Texas, elected to that court. These district courts, right, have their own geographical location that overlaps possibly counties. So you may have a district level court that overlaps one or more counties. You may have a district level court that is wholly within a county, right? It's whatever the geographical area the state legislature defines for that court. And it's going to be based upon the level of court cases that are coming out of that area, which is going to be pretty much directly tied to the population density of an area, right? The more people you have, the more cases you have, the more cases you have, the more courts you need. Okay, so the district level courts, these state trial courts of general and special jurisdiction, they have an original jurisdiction over any civil action of $200 or $500 and more. You've heard that before. Constitutional county courts of law, justice courts, right? So again, we have this overlapping jurisdiction issue that we mentioned earlier. They also have original jurisdiction over divorce cases. They have original jurisdiction over disputes over titles to land. And they have original jurisdiction over contested elections within the state, which in the last couple of years we've seen, right, a lot of allusions to contested elections and whether elections were done properly or not. And you're looking to apply state law to these elections to see were they done properly. That kind of case is going to start at a district level. District courts, and this is where you see much of their caseload, have original jurisdiction over felony criminal matters. And we'll talk in a little bit about the difference between misdemeanors and felonies, but generally speaking, all felony criminal cases carry the potential for incarceration. And maybe more, maybe death penalty, right? Maybe 40 years or life in prison. So you're at a much higher level of judge here with a higher level of case concern, and this is where we're going to bring all of our felony criminal cases will start here. Notice also that same as constitutional county courts, district courts have the ability to hear juvenile matters, right? Which is, again, a specialized area of law within the state. Of those 445 courts, 13 of them, those district courts, have been designated criminal district courts. In other words, they're hearing only criminal case law, right? Criminal court cases. They're not hearing civil actions. So the state has seen the need for specialization in some of these places, right? And so again, you're going to see those criminal district courts in Fort Worth and Dallas counties and Harris counties and Travis and Williamson, the high population areas of the state. So you'll see those. And then notice here at the bottom, this last little element, 348 of our districts contain one county. In other words, the district court and the county demarcations are the same. But 97 of our districts overlap counties. And you're going to see that overlap, generally speaking, where there's either high population areas where you're splitting a county between multiple district courts, or where you're going to be in a very low population area, and a district may have multiple counties in it because all of those counties are sparsely populated. So that federal district, state level district court will be larger to encompass enough people to fill out its need. Now, excuse me. One of the interesting things here as we look at moving up is there are two different levels, of appeals coming out of the district courts, depending upon what type of case it is. Generally speaking, the primary appeals process out of the district court is to appeal to the Court of Appeals. The only time you don't appeal to the Court of Appeals is if in the district courts you had a case that was bringing with it the potential of a death sentence, and that district court applied a death sentence to that case. So anytime the district level, you've got the felony criminal matter, and it carries with it the potential of the death penalty in Texas. If that district court applies the death penalty and says what you've done is so heinous and so wrong that we think you need to, forfeit your life, the state needs to take your life. Statutorily, we have it set up that it will be automatically appealed to the Court of Criminal Appeals, so that's that appeals path on the far right-hand side there coming out of district courts. District court decides that someone needs to be put to death. We automatically generate an appeal to the Court of Criminal Appeals. And this makes a lot of sense when you think about it. One, we don't have just a ton of these cases, but two, the penalty that the state is looking to apply here, can't be turned back, If you execute someone, that's a done deal. And so we need to make very sure before we apply that ultimate penalty to an individual that we've reviewed everything that we need to review, and that the district court did its job, and the judge did its job, and the jury did its job in the district court when they applied this penalty, and they did it properly. And so we have an automatic appeals to the Court of Criminal Appeals, which is the highest level of criminal appeal court in the state, and so their job is to only do appeals on criminal cases. There's judges, that's all they hear, and they always hear the appeals on death penalty cases that are automatic coming up from the district court. So before we ever apply a death penalty to someone in Texas, we have a guilty finding at a district level with an automatic appeal to the Court of Criminal Appeals, who review that whole case to determine if the district court did its job the right way, and remanded it to the district court if it doesn't, or to sign off on that automatic appeal and say, yes, the court did its job appropriately, the law was applied appropriately, the death penalty in this case makes sense. That automatic appeal is not exhaustive. In other words, the individual that receives the death penalty still has the ability to appeal their case on their own. But that automatic appeal gets oversight guaranteed on any case where there may be a death penalty. The rest of the appeals cases coming out of district courts will go to a court of appeals. We have 14 courts in the state of Texas that are courts of appeals staffed by 80 justices. Their job is appellate only, They only hear appeals cases. They only hear those appeals cases coming either out of the county level courts or out of the district courts. And whatever case, whatever court it comes out of, it's directed to a particular court of appeals, They have their districts as well. So Trial courts, these lower trial courts, appeals come up out of them to courts of appeals, whether they're criminal or civil, in every case except death penalty cases. And so then they will review the records of the lower courts, make their decisions as to whether to remand a case for, a reapplication of law, directing that court to do things appropriate given this particular law and how it's supposed to be interpreted. That lower case will then apply it that way. In the cases where even the Court of Appeals is questioned, you can appeal a case from the Court of Appeals up to the final highest level of appellate courts in Texas. The Supreme Court, if it's a civil case, Texas Supreme Court, or the Texas Court of Criminal Appeals if it's a criminal case. So the type of jurisdiction will determine which court it goes to. These are the highest level courts in Texas. And so decisions made at this level have a sense of finality to them as they are remanded back down or affirmed if the lower courts did their job. Notice that you only get to these two courts through either the Court of Appeals or in the unique circumstance of a death penalty case, right? So those are our courts in Texas and their appropriate levels of jurisdiction. Okay, so let's review a little bit of what we've mentioned, or I've mentioned when we've looked at the Texas court structure, right? The first and biggest problem is what we refer to as the overlapping jurisdiction. In this case, of course, what we're talking about is that ability to go judge shopping by prosecutors and or in civil cases, the attorney that's bringing the lawsuit. For a judge that might be more or less fair than as they ought to be. So again, there's no guarantee that an attorney that goes judge shopping will actually get exactly what they want out of a situation. But the perception is there that the ability to choose where you initiate a lawsuit or a case, and having that ability to look at who the judges are that serve in that court, it smacks of potential, lack of impartiality, and so that's a really bad look to have when you're looking at a justice system. You're looking at determining guilt, innocence, right or wrong. Right, the whole idea, right, if you think about it, is that justice is supposed to be impartial. Justice is supposed to be blind, and the fact that attorneys that may have some kind of influence over maybe the outcome of a case by where they initiate a lawsuit is a problem. The other ones are rather administrative, but there are still important kind of problems to consider, and that's that having multiple places to take the same lawsuit is a duplication of effort. It's a waste of money and time, right? It's a waste of the specialization of the judges, right, and of the courts. So it would be much better from an efficiency perspective if we were to reframe these so that, dependent upon the case you're bringing, what type of case is and the parameters of the case, there's no choice about what court you go to, right? If you're in this geographical area and it's a case of this magnitude, it goes to this court, period. Because then it allows you to organize, right, the structure of the court, where the courts are, how many we have, right, based upon real numbers coming into those areas, right? You won't have to worry about, well, this case could be filed A, B, or C, and we need to make sure we have the capability to handle those number of cases at A, B, and C. You would know that, okay, we got 10,000 cases like this last year, And as a legislature, that we're recognizing that we didn't have enough bandwidth in the system, we will expand this court, right? We'll add another court here because we know all those cases come right into this administrative realm of the level of the courts. So we could make our court system more fair, or at least the appearance of being more impartial. We could make it more effective and more efficient if we cleared up, right, these problems with overlapping jurisdictions. Okay, so let's look at the judges that fill the qualifications of the judges that are individuals that can run for these courts and what they have to have. This is kind of scary when you look at it, right? But you got to remember that a lot of this is tied to historical circumstance, right? That these courts have been around for a while. So let's look at them, right? At the base level, right, you have your justice of peace courts and your municipal courts. Those municipal courts, right, are courts that have been created by city ordinance, right? The municipality has created them. A majority of our cities, of course, have come along at a later date. So they're going to be fairly up to date in their concerns about what they want in their judges. I'm going to hold off on this just a little bit, and I'll show you an example of municipal court requirements that come out of cities here. Generally speaking, though, cities set up their municipal judges to be elected or selected, as the case may be, for a 2-year term or a 4-year term. What they get paid is determined by the city, right, and what their budgets are. And the qualifications I'll show you later, which are interesting. And they differ from obviously city to city because the city has the ability to determine what those are. At the other side of the very low level of our court structure is the justice of the peace courts. Remember, these are precinct courts established at the county level, and they are, right, sitting down there historically, right, as justice of the peace courts that have been around for, many years. And so the justice of the peace, right, run for their position. They're elected to a 4-year term. What they get paid is determined by the budget of the county that the justice of the peace court is in. So each county has 4 precincts. They have 4 justices of the peace courts. So the county will determine what each justice gets paid based upon the budget of the county. The interesting part here is the last one, and that's the qualifications that go along with getting this position. And really, I say there are no qualifications, and that's because, it's because there are none, right? You're not required to have anything, right, as far as a level of understanding or experience or age that qualifies you for this position. The qualification to become a justice of the peace is that you win the election. So if there are any qualifications, they're going to be qualifications that come about from what do you have to qualify to run for a position. In this case, in Texas, there's not any, right? You just have to fill out the paperwork and then run your campaign and be elected, which means that effectively anybody could be a justice of the peace. Now, here's where our method of judicial selection in Texas comes into play and has at least some potentially beneficial effects, right? You have to win an election. So if you're, right, 14 years old and decide you want to run for this position, people will take that into account, right, as they determine whether they want to vote for you or not. They may look at it and say, hey, this is the justice. Does the person have a law degree? Are they an attorney? Have they got any kind of training at all in this? Now, it's up to each individual voter to decide what the qualification is going to suffice for them to vote yes or no for yes for someone or yes for somebody else. So it's not practically fair to say there are no qualifications. There will be qualifications applied by the voters as to what they think is appropriate. But there are none that are required by the state or by the Constitution, right, to be eligible to run for this position. So that's interesting, right? We move up one level and we look at the constitutional county court at law, right, which the Constitution of Texas says there will be one of these in every county. Again, this is, judge positions in Texas other than municipal ones are elected. So this is a 4-year elected post, and you can run for re-election as many times as you like. The county, again, will determine what the salary is at this level. And here is the qualification written into the Constitution for this position. To be eligible to run for constitutional county judge, you need to be well informed in the law, which is technically a qualification, although it is a very broad qualification that can be interpreted by anybody to be whatever they want it to be. So it'll effectively be none or very high, it just depends. Again, right, we're relying upon the elections process here to weed out those that we think wouldn't be qualified for this position. Maybe that works and maybe it doesn't, right? Notice that the companion court, right, the county court of law, which is, remember, the exact same jurisdictional levels plus some that these courts have that are created by the statute by the legislature, right? 4-year elected term, county determines the salary, but look at the qualifications, right? Here's what our legislatures believe ought to be the qualifications to be a judge at the county court of law, which would lead you to believe possibly these should be the same qualifications for the constitutional county court of law. Now, right, what we're looking at here is an age requirement of 25. We're looking at there's a residency requirement that they live right in the county for 2 years prior to being elected. They be a licensed attorney in Texas, and they have 4 years of experience practicing law or serving as a judge. Right, that's a much higher level of qualification. Seeing that the constitutional county courts and the county courts of law have the same jurisdictions, essentially, it would be right normal to expect that would, if we were to rewrite the Constitution of Texas, we might apply these qualifications for constitutional county courts judges, although that is not the case currently. But if we ever get there, and we might, right, we would probably expect to see that type of qualification written into the Constitution. Or it might be that we amend the Constitution of Texas to say the qualifications to fulfill, successfully run and fulfill the constitutional county court at law will be equivalent to the qualifications of the county court at law as determined by the legislature. Could do something like that, maybe. Moving up one level to state trial courts, right? We're looking at the district courts here. These folks are elected to 4-year terms. Now, because these are state trial courts, salaries are determined at the state level, right? Not at the county level. And you see that the remunerations that you're going to get is fairly substantial, right? That's pretty decent salary here, $125,000. These have probably been adjusted upwards a little bit since I grabbed this qualifications chart, so probably a little higher than this now as they get adjusted by the legislature. Also, look at the qualifications here. We have not only a minimal age qualification, but a maximum age qualification, right? You must be between 25 and 74 years old, as you're running for office to be elected to this position. You have to be a citizen of the district, or a citizen of the state, a resident of the district for 2 years, a licensed attorney again, and 4 years of experience either practicing or serving as a judge. So we've got some fairly substantial qualifications coming in at the state trial court level. When you move to the appeals courts, right, we have here the three appeals courts that are exclusive in their appellate jurisdiction. We have the Court of Appeals, right, which is where all of those district court appeals come to, and some of the county court of appeals, the county trial courts come to. Here you're elected to serve a 6-year term, so we've bumped up the how long you're in office. And you see here at the state level, right, we're providing substantial salaries as well. Here you need to be a citizen. This is a U.S. citizen, right? State citizen, you need to be between 35 and 74 years old when you're elected. You have to have 10 years practicing law. And notice here, well, not and, I'm sorry, 10 years practicing law or 10 years serving as a judge for a court of record, which means, right, not a justice of the peace. So, right, you have a history, a 10-year history of written court opinions that can be looked back on and used as an evaluation of your ability to be a judge. The top 2 level, right, the Court of Appeals, the Texas Court of Criminal Appeals, similar in their periods of how long they're elected to, similar in their salary requirements, and very similar except for the age requirements for their qualifications. Again, citizen, criminal appeals, 35 to 74. Your age, 10 years on practicing law or serving as a county judge. The Supreme Court doesn't have the same top level limitation on your age, but other than that, it's the same as the Court of Criminal Appeals. We did have a constitutional amendment that appeals that applies to some of these qualifications that we'll see if those when that's elected, when that election happens in November, whether or not we'll have a constitutional amendment that changes some of these qualifications. Okay, I told you earlier we'd look at an example of a municipal court judge and what their qualifications are. This is Ordinance in Cedar Park for how they do go about their business of putting a municipal judge on a bench. Right, it says here right under section 4.02, right, there will be a municipal court for Cedar Park, and that it's will be designated, right, to try misdemeanor offenses prescribed as by the laws of Texas for municipal courts. So, right, they just basically say whatever the state says we can do, these courts can do. Notice here that the municipal judge in Cedar Park is appointed to their position. They're not elected. They're appointed by the city manager. And then the city council, right, approves that appointment of the city manager. And then, so what you have happen here in Cedar Park, right, you have a type of city council that is sitting over, right, the city and making decisions as far as ordinances for the city, but they hire a city manager to do the daily running of the city's business. And part of that city manager's job is to appoint municipal judges. Limitations put on that appointment is that the city manager must appoint a licensed attorney in the state of Texas. Right. So while a justice of the peace, right, that has no qualifications for getting elected to their position, the municipal judge, which is, right, fairly equivalent in their abilities, although they also have ordinance responsibilities, has to actually be a licensed attorney in the state of Texas. What they get paid, how long they serve is determined by the city and by the city manager and city council. And then as you go through this, it makes some, brings out, if there's going to be a clerk, again, appointed by the manager. The clerk will do these kind of duties. So you get a clerk that works within the municipal court, right? If they need more judges, the city manager can appoint additional judges, right? Again, based on the authority that the city council lays out there. And then there's a requirement down here that the judges that are appointed be bonded for no less than $100,000, which is essentially ensuring that there is insurance on the decision of these judges, and that'll be backed up by this bond at the city level. So, right, and each city can do this differently, right? It depends upon the ordinances of the city. Okay, so let's stop this lecture here, and we'll pick up next time looking at judicial conduct and judicial selection.